It's got a bond violation.
Ready? Come up, Mr. Steyer.
Not sure why he has this device on his phone.
I don't know, but a bond condition is a bond condition. And when you don't live up to the bond condition, there are consequences, just like anything in life. When you have a criminal case, you have conditions that you have to live by. And when you don't, there are very serious consequences. Mr. Steyer, you're on bond for fleeing a police officer. So the report is that your device is in lockout, and it's been in lockout since 10/24.
Sorry. Judge, can we address the need for this bond condition?
Bond conditions aren't suggestions, they're orders. One violation, one mistake, and everything starts collapsing. In this courtroom, excuses won't save you.
I don't remember the case, so let's do PC real quick,
Yes, Judge.
and then we'll go from there.
So on August 17th, 2024, at approximately 2 a.m., the officers observed a vehicle with a defective tail lamp and tried to initiate a traffic stop. The vehicle had ample opportunities to stop at multiple well-lit parking lots, but drove 0.46 miles of the final stop location. The defendant had red glossy eyes and continuously, I apologize. The defendant had red glossy eyes and the vehicle was running, and the officers also observed a slight odor of an alcoholic beverage from the defendant's body. The defendant had slurred speech and repeated, "I'm just trying to go home. I came from work," but the defendant could not specify his place of work. The defendant denied drinking alcohol, and the officers found an open container of color XO brandy container under the driver's seat and a Taurus pistol under the passenger seat without a holster.
So what bond conditions were on there that they're alleging him to have violated? Let's see. You want to help me out?
Sorry?
This is Steyer,
Yes.
please.
I have one here. He doesn't have any previous violations, it's just that the device is in lockout.
What device?
The ignition interlock device.
So they put an ignition interlock. I guess the magistrate put an ignition interlock on it.
Charged with DWI.
Yes, conditions were ordered on August 28th. And
I get it, but he's alleged of alcohol in the car. I don't know. How, I mean, begs the question, why didn't they charge him?
It should have been a DWCW judge. We're talking to this officer. It should have been a different charge.
I can't say this should have been a different charge. We're supposed to, officers are officers. We're supposed to allow them to do their job. And when their job doesn't rise to what folk think it should be, then all of a sudden they didn't do their job right. We want to talk to the supervisor. Officer didn't charge him, he didn't charge him. So he only got charged with fleeing. I don't understand why he's got this device on
Did
his
they
car.
do field sobriety tests?
They did not, Your Honor.
There was no DWI investigation done at the scene.
Was there any indication that he was intoxicated?
Yes, he had slurred speech, red glossy eyes.
And an odor of alcoholic beverage.
Yes.
Maybe the officer didn't think it rose to the event. At any rate, the officer didn't call it in as a DWI. And whether the state thinks it's shoddy work or not, we don't punish the defendant because the officer did shoddy work.
Punish them for having bond conditions and not.
I fully understand that. And that's why I wanted to address the need for the bond condition as well as the bond. I understand that the machine's not working or it's in a lockout status, but I'd also like to address why. Why are we having it? So you didn't put it on there.
I didn't, but I think that it's a reasonable restriction when it is, for all intents and purposes, they just didn't charge it because maybe they had an officer that was a rookie, didn't know what they were doing. I can't tell you how many reports that I have see here that might as well have been written in Mandarin, you know?
From the defense perspective, this is.
I understand
that
it.
we have to work with, and if they've got a rookie or if they've got a shoddy investigation, that shouldn't be his fault. Then that's their
But
issue.
it is his fault for not complying
Absolutely.
with the bond condition. That's what happens now, Mr. Steyer.
Just don't say.
What? What can you possibly say that can help?
I don't, like I was saying, I don't understand why it's locked. I called the people about it. I told them they were like, it's a troubleshoot with your device. We'll try to figure it out on our end. But they they never gave me no information about what to do.
He can remedy that today, Judge.
No. I want to figure out now. I'm not going to let him go and then try to figure it after the fact. I'd like to do it now.
Senator.
What do you think? Do you know why it's in lockdown?
I don't, that's what I'm looking at right now. So, because for all of our other devices, we have been sent to them, but since we have a third-party vendor for the addition year lock, I don't see anything on the 24th or past that until the email sent to the HR.
Would you mind looking into, please, as to why it's in lockout? It might take a little bit.
I
And
understand.
have you take a seat in the jury box while we figure this out, and then maybe 5-10 minutes, we'll come back and we'll
I
see.
understand.
And then,
From the defense perspective, we should still address the need of this. I mean, the officer is part of the state. He is part of the state's witnesses. They didn't make the allegation. They didn't file the charges. I'm still contesting outside of the fact that the machine doesn't work. And mind you, he didn't make the machine. He doesn't calibrate the machine. If the machine doesn't work, that could be no fault of his own, and we can correct that today. But if
let's do this, Mr. Slider.
yes,
I was gonna send you now for a drug and alcohol test. Let's see what pops up. You know,
that's
we
fair,
can
Judge.
see how he's been behaving while he's on bond.
My drug test comes back with nothing on it. It will leave.
Yes. This question is if this drug test is free and clear of any alcohol, any drugs.
Let's cross that bridge when we get there.
We'll do,
Send you
Judge.
for a test now, and we'll go from there. If you're clean, it'll go a long way for you. If you're dirty, we'll cross that bridge when we get there.
Sir.
My only concern, Steyer, is public safety. Nothing else matters in my life. And if you're gonna play adult games, or if you play stupid games, you win stupid prizes or you get adult consequences, right? When you act like a child, we treat you like a child. If you do great things, then we congratulate you and reward you, right?
Sir.
Okay, just take a seat from the room, Chair. We'll be
Thanks,
back. All right, Mr. Slider.
You
So,
can go ahead and-
I'm not happy with it. It's unacceptable. It's unacceptable. He's in lockout. A court order is a court order, you know? He's in lockout because he failed to go get it calibrated. Not because of this, not because of that, because he didn't call, no. You failed to go get it locked down, or you failed to go get it calibrated. That's why it's in lockout. I send you to go to test, and now you're testing positive for alcohol. Guess what happens now? That's right. Actions have consequences, Mr. Steyer. He goes with you. I'm sorry, but I can't continue to do it, man. It's unacceptable.
Judge, are you revoking his bond? What are you gonna set the new bonds at?
5,001.
5,000 more than the original bond,
Oh,
or just 5,000?
what's it at now? Is it 100?
Let me check.
It's at 100. So 5,001.
So $5,000 bond, okay,
5,001. Yeah. Okay.
okay.
Goes with you. All right. Sorry, Kavita, but it's just too much.
Thank you, Judge.
How are you?
Hey, what's new?
I have an off docket, is that okay?
No problem.
Okay. The cause number is 255-2517. This is for Brandon Brown.
Okay.
I am not his counsel on the misdemeanor case. I'm his counsel on the felony case. I was informed from misdemeanor counsel that we wanted to put him on the docket. He's on the docket Monday here because he didn't have a felony bond. And so,
We want to, no, I think that
right? Okay.
we wanted to,
Like figure out what was happening in felony. Okay.
and here, because he just picked up a new case. He's on bond for at least one case with us. So we're going to put it to speak about his bond situation. That's
Yeah, so I just came back from felony. I was appointed on Tuesday. He did not receive a bond that day because he was on a parole hold. And then that,
parole hold now.
no, it was lifted that same day that I was appointed. And we couldn't tell because, I don't know if you remember on Tuesday, like all the defense attorneys were kind of locked out of the internet and I couldn't check. So anyway, parole hold's lifted. And so on Monday, we put him on for Monday in felony to get a bond. there and probably, hopefully resolve it that same day because the case is old. Yeah, it's from 2023.
Right.
So just wanted to make Mr. Muir aware,
Is that gonna swallow this one up too, you think?
possibly, possibly.
Get the cost number?
Yes,
Is there a global offer?
there is no global offer, Judge. So he's got the 3 misdemeanors here and the 1,
He has one, two.
He has two,
He
but
has
You see.
2 evadings and a POM, from what
I got no PC, I think. Or is it still open? Did you guys know?
it was discharged, no PC. It's not dismissed yet, Judge.
It's not dismissed. Okay. So yes, technically, I mean, well, there's nothing that I can do with that. I mean, that's right.
Right.
So,
So just wanted to make the court aware. I don't know if y'all want to put it for Tuesday.
okay. I have to let Ms. Strong know too. I don't, are we expecting?
I emailed her.
Mr. Smart here?
I think he came up with
Okay.
inspector.
Okay. So I don't know, maybe we'll see her. But yeah, we'll put it on Tuesday. That's fine.
Okay, and then if we resolve it Monday, we resolve it Monday.
Okay, did you get the cost number?
I can smart.
No, we're talking about, I was just curious about Mr. Smart. Let me give you the cost number. You ready?
Okay.
It's 255-2517. And then there's 2 cases for you to move.
2517?
Yeah.
Okay, what are we doing?
Just on Tuesday, 3-4. Both cases, please. Okay?
That's all I have, Judge. It was good
Have
to see
fun.
you.
You too?
I just put 2 bond conditions in here.
Okay. Mr. Butler, I was thinking Mr. Dixon for a second, but
Thanks. I have Mr. Flynn on the docket this morning for arraignment.
okay, you ready?
Yeah, Mr. Flynn?
Lynn. Oh, Finn.
Yeah, yeah.
Finn, yeah. Good morning, Mr. Finn. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On February 22nd, 2025, at approximately 11:07 p.m., an officer was dispatched to 59 Northeast Cross Timbers on City Street. The officer observed a vehicle run a red light, take the exit, swerving in and out of lane number 2 and cross 3 lanes of traffic, almost striking a guardrail. A traffic stop was initiated. The officer observed the driver to have bloodshot eyes, slurred speech, and the strong odor of alcohol. The officer had the driver and the passenger exit the motor vehicle. The driver consented to SFSTs and the defendant performed them. 6 out of 6 clues were observed on the HGN. 5 out of 8 clues were observed on the walk-in turn. 3 out of 4 clues observed on the one-leg stand. The defendant was read the DIC and consented to provide a breath specimen. The results were 0.141 and 0.138. The defendant advised he had 1 drink while at a bar, and he was the owner of the vehicle, and he was identified by his Texas driver's license.
Any prior DWIs?
No prior DWI, Judge.
Valid license?
Valid license.
All right, Mr. Finn, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, your bond will be revoked. You will go into custody. No more PR bonds. Do you understand?
Yes, sir.
Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them, and they'll tell you if and when you have to come back to court. If they tell me they can't get a hold of you because you're ducking and dodging, I will issue a warrant for your arrest. Just keep my city safe. That's all I want. You understand?
Yes, sir.
I'll have you sign a receipt with Victoria. We'll have you get with police for your bond conditions, and then you're free to go.
Thank you, Your Honor. Good morning, Your Honor.
It's not a good morning. No. You are using my name on an occupational license, and you're not in compliance with what you're supposed to be doing. It's unacceptable. If I find that it happens again, I'm going to yank it. I want to make sure that you're not using while my name is on the license. Do you understand?
Yes, sir.
I'm sending you now for a drug test. I want to make sure that you're not using. And then if I don't know what I'm going to do, the first thing I want to send you for a drug test to make sure, and then we'll go from there. So we'll send you and then we'll have you come back.
Yes, sir.
This is who, Judge?
No, don't worry about it. I'll have
Okay,
tutorial.
thank you.
Thank you. Oh, okay, got it. Okay, yeah, yeah, okay. Mr. Beadle, hey,
William Jones, you wanted us to come to docket today, and he's here.
I'd like to send him for a drug test, alcohol test. I want to make sure he's not using though.
If that's the court's prerogative, that's fine. However, he is checking into the Menninger Clinic tomorrow after his rehab from Ohio.
How long has he been?
And I'll be very frank with you, the last time I was here with him, he looks like $1 million compared to the last time I saw him. And I've been speaking with him very frequently on the phone. I'm more than happy for you to talk to him, Judge, frankly.
Come up, sir. The last name is, this is Jones. We're here because Mr. Jones doesn't have his interlock that he was required to, and he's been out in lockout for quite some time.
Correct.
Which is unacceptable, right? If you're in rehab, we have to know, and there are certain measures that we can take, but just if you don't tell us anything and you're just in lockout, that's a problem. I have a real big problem, and I don't know you. Everybody tells me it's little raindrops and gumdrops and little bunnies jumping in the woods, but how the hell do I know? So he's telling me that you've been in a rehab in Ohio.
Sir.
When?
The last setting that we were here, the prior setting to this, Judge, he got on a plane from the courtroom and went off to Ohio. And I actually forwarded the court his admission paperwork to that facility in Ohio.
What was the date of release from that program?
It was last Friday. I spent 8 days in the hospital detoxing, and then the rest of the time in the rehab. And, I'm trying to put together a forward plan. I'm not supposed to be talking too much, but to take aftercare and go back to another rehab here locally and work on getting better. And I'm being proactive with that, Your Honor. He's had to change insurance.
That's all we ask, because the problem is that some people can, and some people can't. Addiction, it's a lifelong, and it's a persistent monkey that's on your back that will never let go. It will constantly grab at you. So if you're not proactive about it, that's when it grabs you by the boo-boo, and it just doesn't go well.
Sir.
I just need to make sure that you're not using, number one. Number two, most importantly, that my public is safe, because I certainly don't want you in a car unless, everyone is protected. And the way we know that is that you don't have alcohol on board. So what I'm going to do now, because you've been so AWOL with regard to this, I'm now putting a monitor on your ankle so I know that you're not consuming. If it goes in lockout again, I will put you in jail. I want you to know that. I'm not going to do this again with you. Do you understand? You've been in lockout for a significant amount of time, and it's not fair, because I normally would put people in jail lickety-split for something like this. Do you understand?
Sure.
I will not play this game with you again. It is your responsibility to charge it on a daily basis. It is your responsibility to know what you are putting in your body, as far as, whether it be mouthwash, hair dye, a tequila lollipop. I've heard it all, and I don't care for excuses. It is your responsibility to know. You've got such a great team of lawyers, there's just no excuse.
Sure.
I will waive the fee so that there's no excuse for, well, I can't pay for this, I can't. No. Do you understand?
Your Honor.
What you do on your time is you. As long as I know that you're not using, I'm happy. Do you understand?
Yes, sir.
Okay.
I'll be happy once he checks into the medical point. He can alert the DAs, the court. Everybody.
Yeah, I guess we're going to give him the SCRAM device today. Just keep us in the loop as far as the cases are too terribly old. It's not old. So just keep us in the loop of when he's released. Just, you have to calibrate this thing on, I I think it's monthly. So make sure that you calibrate this thing like it's supposed to. They have to download it. You've got to charge it. So make sure you know of everything you can and can't do. You understand, Mr. Jones?
Yes, sir.
If I have you come up here on another violation, it's probably not going to go well, just so you know. Okay? Okay, guys.
Understood. Thank you. Can he be released?
You can argue facts, but you can't escape responsibility. Ignore the rules, and the system responds fast. In court, compliance isn't optional, it's survival.